Okay, good afternoon, everybody. We're going to get started. I want to welcome you to our webinar on financial planning for individuals and families who have children. I want to let you know that today we are live streaming this webinar on Facebook. We will also be recording. It will be available on Facebook moments after we finish, and then it will be also available on YouTube and our website by the end of this week. If you have any questions, please feel free to enter them in the chat box. I'll be monitoring the chat box, and we also have an employee monitoring the chat box on Facebook. So use your chat boxes to ask any questions, and we'll get those answered for you. And at the end of the webinar, we do have a poll. So if you could take a few moments just to fill out the poll, that really helps us as being a nonprofit grant-funded agency. We rely on your feedback to make sure that the services we're providing are quality and to continue our funding. So with the housekeeping out of the way, I want to take the opportunity to welcome Jacki Farrell, a financial advisor at Edward Jones with 15 years of financial and a mom to a son with autism and an intellectual disability, as well as Tudor Goldsmith, a practicing lawyer at Jensen Baird Henry in the area of trusts and estates, probate, litigation, and related tax matters. Today, they're going to be talking about investing principles to achieve your long-term goals, how inheritance can affect a person's eligibility for MaineCare, proactive inheritance planning for families with children with special needs, and additional options for special needs financial planning. So with that introduction, I will turn it over to Tudor and Jacki. Thank you both for joining us today.
Thank you. So first, I'd like to say thank you for this opportunity to allow us to be here today to talk to all of you. I'm really excited to share some information I feel is very valuable, especially to families who have loved ones with disability. As Carrie said, my name is Jacki Farrell. I'm a financial advisor with Edward Jones. I'd like to start by telling you a little bit about me, then about our process at Edward Jones, and then we'll turn this over to Tudor. I'm going to try to keep my words brief because I think it's pretty important to hear what Tudor has to say. I want to give her plenty of time. So it's my goal for all of you to leave here today thinking about how you can meet your own financial goals while securing the well-being of your loved ones. As a financial advisor at Edward Jones, I strive to develop long-term relationships with my clients. I have 20 years of financial services experience and recently transitioned to be a financial advisor at Edward Jones. I love saying that I started in this industry when the Dow was at 8,000, and it's now about 25,000. It's been an interesting journey. I also have a son who has intellectual disability and autism. I've spent 14 years as a single mom with 3 kids. I can fully understand the day-to-day challenges of managing it all and taking care of a child with special needs. It's been my passion to use what I know about investing in financial services, along with my personal experiences, to become a resource for families like ours. The part of my work I enjoy the most is helping my clients meet their financial goals and giving them a peace of mind to know their financial lives are organized and set up properly. One of the reasons why I chose Edward Jones is because of their unique approach. We have a 5-step process that helps us manage our client relationships. I feel as an advisor, it's a process that ensures that we have done everything we need to for our clients. Step 1 is spending some time talking to our clients and getting to know what's really important to them. We want to know what our clients worry about the most. Is it premature death? Is it being comfortable in retirement? Is it paying for kids' educations? Whatever that may be. And also, I like to ask, what is important to them in a financial advisor? We will work together to develop some goals based on their needs. Some goals may look like preparing for retirement, living in retirement, preparing for the unexpected, whatever it is that that particular need is for that client. We'll also talk about risk. And risk is what you can stomach for swings in the market. Understanding risk and how much you can take or need to take to achieve your goals is very important. Having the right balance between higher return potential and the risk you can expect is critical in staying the course and achieving your long-term goals. We'll also talk about diversification, which is the mix of investments in your portfolio, like your stocks, your bonds, your cash, your international investments, and having the proper mix can lower your risk and smooth out the ups and downs over time. At Edward Jones, we focus on quality investments. You'll never hear me talking about the stock of the day. We look at investments that have financial strength, track records over time, which may provide the ability to overcome challenges in the long term. So using all of this information, we'll put together a strategy. And within that strategy, I'll make some suggestions on how to get you to where you need to be, what types of accounts you might use, how much you might need to save or how much you can save. We'll make sure you're taking advantage of things like your 401ks and your matches. We'll talk about Social Security, medical costs and retirement, tax planning, insurances. Insurances play a valuable part in long-term planning. With the systems and the resources that are available to me at Edward Jones, I can show you how much you might have at retirement and how much you could have at the end of your life. So lastly, we'll use this strategy as a guide and partner for life to stay on track, making changes as life changes. As an advisor, I can help pull this all together. We can also pull in attorneys, CPAs, and tax advisors as the need is there. Setting yourselves up properly is an important first step. So at this point, I'd like to just shift gears a little bit and talk to you as a mom instead of an advisor, and a mom with a child with a disability, and tell you a little bit about my situation. My son is 23. He currently lives in a group home. We're hoping with the right supports at some point, he'll be living more independently. I love the place where he is. It's really good for him. He's safe and protected. He didn't want to live with me anymore, so we've got a great situation for him. He isn't working right now. Holding jobs has been extremely hard for him. We are working with both rehab, and I'm hoping that things will change. He gets Social Security. He has 2 kinds of medical insurances from the government. I don't understand all of his benefits and all the qualifying factors to get them and how they work, to be honest with you. He does have Social Security that pays his rent. We have a case manager who I love, who's been with us since he was 18. She helps with so many things, and I depend on her. She's helped us pull these services together and make everything happen. He does some other types of therapies here and there. And as you parents on this call know that we can't always privately pay for the services that we need for our kids. And some of these services are needs-based. So if I were to pass away, or a well-intended relative passes away, and they leave money for him, it could interrupt some of these services that he relies on and that I really need in place. So the thoughts of him losing these benefits really scares me, especially if I'm the one who passes away prematurely. I really wouldn't know what would happen to him. Not to mention he could have access to money he doesn't really know how to spend properly. So I've done some estate planning. I know that sounds scary to some people, but it's not. And it's also not as costly as some people envision, especially if you have your thoughts organized and a strategy in place as a first step. So estate planning is simply a set of legal documents that will protect assets and services for our loved ones if something were to happen and they inherit money or we pass away. So one of the things I set up was a special needs trust. Right now, it's a piece of paper that would be used if I pass away or if a relative leaves him assets. Then the trust becomes funded by the assets or life insurance. I have a trustee who will help him manage his funds if I'm gone. This will protect him and his benefits. The money that goes into the trust account is his money. It's to be spent on him, but he doesn't have direct access to it, so that's what protects his benefits. And then the beneficiary information on my accounts and things like life insurance and retirement just read to the estate of Jacki A. Farrell instead of going directly to my kid. And his portion would go into a special needs trust. So that I wanted to share my personal information with you on estate planning because it is really important that we all talk about that and really think about that. And I want to mention that I'm really happy talking to people and helping people. So if anyone wants to talk after this seminar and they want to reach out and just talk about their situation, or if they have any questions, please feel free. And also, so actually I'm going to turn this over to Tudor now.
Hi, everybody. I'm Tudor Goldsmith. I'm an attorney with Jensen Baird Henry in Portland, Maine. My area of practice is estate planning as well as estate administration. So in terms of what I'm doing here today, we're here, of course, on the estate planning piece. And so I want to kind of break things down into 3 parts here. First, I want to do just a very brief overview of special needs planning and what it is. Then I want to get into the importance of planning on the front end versus on the back end. And then finally, I want to just briefly discuss how to get started. So just a general overview of means-tested benefits, and Jackie touched on this as well. So means-tested benefits are benefits that are available to an individual or an individual's family for people with disabilities. And they include SSI, Medicaid or MaineCare as it's administered in the state of Maine, and the SNAP food assistance program. So by means tested, I mean benefits that are only available to a person if their so-called countable assets are below a certain limit. And it's a bit beyond the scope of things today to talk about what is or what is not a countable asset. But generally speaking, any cash, investments, those are going to be countable assets. And so for most people, when they're looking at leaving money or property to a loved one with special needs, they're looking at passing along their retirement accounts, their investment savings, their cash in their bank account. So it's extremely important to be sure that those types of assets are not going to become countable assets for your child or other loved ones with special needs after you pass. So moving on to our second topic of the importance of planning to protect means-tested benefits. So I want to start off with a scenario here. We have a parent who does not engage in any estate planning or an estate planning that contemplates the special challenges that that person's family may have. Their child with disability ends up inheriting, let's say, $200,000 and the family can't. That's been in the family for years. So what's going to happen? So first, that inheritance is going to be considered income in the month of receipt. That means that no matter what else happens, that child is definitely going to lose their benefits for at least 1 month. Then what happens in subsequent months? If the child, and I talk about a child, but this could be a grown-up as well. I don't mean a minor child. I mean a child of the person. If the child does not spend down the assets, if they still have those assets the following month, which one would hope they don't actually go through their inheritance in 1 month, then those assets are going to continue to be assets, countable assets, which are then going to affect the receipt of means-tested benefits in subsequent months. All the money is going to go towards paying that person's cost of care that would otherwise be paid by MaineCare, Medicaid, whatever means-tested benefits that person is receiving. So what does the child, the beneficiary, do? Well, they have a few options. And again, these are the options that exist in the absence of front-end planning. So one option is for the child beneficiary to spend down the inheritance. And they may do this in ways that are not necessarily bad. They may use the money to purchase non-countable assets. For certain benefits, for example, MaineCare, one can have a residence without it affecting the receipt of means-tested benefits. One can have a car. So there are ways to responsibly spend down an inheritance so that one qualifies. The problem, of course, is that ideally, when a parent is looking to provide for a child after they pass, they're hoping that there's going to be a nest egg that's going to be there, not that it's all going to get spent on non-countable assets in the month of receipt. So there are really three options available to the child who inherits money without planning and who wants to protect their receipt of means-tested benefits. The first is an ABLE account. ABLE stands for Achieving a Better Life Experience. An ABLE account is simply a bank account with some special rights under the law, specifically that it's, and there are some caveats to this, but that it's the assets in the ABLE account are not going to be considered countable assets for most means-tested benefits, including SSI and including MaineCare or Medicaid. So that's one option. Another option is a first-party special needs trust. A first-party special needs trust is a trust that gets set up either by the court, by a third party, or by the beneficiary, him or herself, where that child is actually the one who contributes the property to the trust. Then a third party has to serve as the trustee, and the third party is limited in what they can spend the trust assets on. Specifically, they're not allowed to spend the trust assets on things that like health needs, housing needs, food, necessities. If those funds in the first party special needs trust are available for those necessities, they will be considered countable assets. The state will look and say, well, if this trust is going to pay for your housing, then why should we? So that's a second option. And a third option is what's called a pooled trust. A pooled trust is a trust that is, it's administered by a group. There's usually a committee that serves as trustee. They tend to be professionals from a range of related businesses. And they essentially will take the assets from multiple beneficiaries who are unrelated to one another and pool them, but keep track of how much has been contributed by each person. And then they will make disbursements to the beneficiary for certain purposes, but not, again, not for others. So there are these three options. Not all three options are going to be available to the beneficiary who has inherited money. A first party special needs trust, for example, can only be set up if a person is under 65. An ABLE account is only available to a person whose disability onset age began prior to age 26. That doesn't mean they have to be under 26, but their disability must have begun prior to age 26. So sounds great, right? There are all these options available. What's the problem? The problem is that, well, number one, there's no guarantee that a person with special needs is going to actually engage in any of this type of planning. Not every person has the desire to deal with usually an attorney to get this done. They may not have the patience. They may, depending on the situation, not have the cognitive ability to understand why this is necessary. They may not want to part with the independence of having all of this money be their own without any limitations. And also, they're, generally speaking, not in a great place at the time that they have to make this decision because they've just lost a loved one. So it's really difficult to try to have those conversations with somebody at that time more than any other time. They're already dealing with a huge crushing life event of having lost somebody very close to them, possibly the person on whom they depended more than anybody else. So that's the first problem. The second problem is that, again, even with this planning, they will lose their benefits for 1 month. That may or may not be a big deal depending on how much money we're talking about. The third issue is that all of these options are somewhat limited in how useful they are. So an ABLE account, for example, one of the biggest issues with the ABLE account is that there is a $15,000 contribution limit per year. So that's from any source. That means that if a person inherits $200,000 in the family camp, well, that ABLE account might help with 15 grand, but it won't help with the rest. They would have to wait a full year before they can contribute another $15,000. There are a couple of exceptions to that, but even so, there are limited exceptions that really aren't going to help in the majority of cases. And a problem with all three trusts, and this is, I think, really the big one for a lot of parents, especially parents who have other children or whose child with special needs has a spouse or child of their own, is that in all of these circumstances, ABLE accounts, first party special needs trusts, and pooled trusts, when the beneficiary with special needs passes away, the remaining assets will go towards repaying the state of Maine for any benefits that it has paid out on that beneficiary's behalf. Little bit of a caveat with an ABLE account, it's only going to be benefits that were paid out since the establishment of the ABLE account. But if we're talking about an inheritance type situation, we're really talking about essentially all that money is going to go towards paying back the state. So that's not ideal. What about your child's spouse? What about their own children? It would be great to be able to provide for them after the child has passed away, or if put differently, to perhaps provide for your other children. Some parents are particularly concerned about making sure there's enough money available for their child with special needs, and in some cases may choose to leave more to the child with special needs out of concern that they aren't going to be able to provide for themselves without it. But by the same token, they would really like to see that money go to their other kids or their other grandkids after the child with special needs has passed away. That is not an option if you're talking about an ABLE account, a first party special needs trust, or a pooled trust. So again, if you don't plan on the front end, even if your child finds a way to preserve their receipt of means tested benefits, once they pass away, any money that's left over, for the most part, gone. That's it. So that's a pretty big deal. So the number one strategy for avoiding that outcome is front-end planning by use of what Jackie mentioned, which is a third-party special needs trust. A third-party special needs trust is the type of trust that you may have heard about if you've done any looking into special needs trust planning. A third-party special needs trust is essentially, well, let me back up a minute and talk about what a trust is, because I think that in some cases there's some misunderstanding about what a trust is or what it isn't. People tend to think of trusts as funds. Oh, it's a big bank account somewhere. That's not actually what a trust is. What a trust is it's a relationship. And it's a relationship by three people or three entities. In some cases, there can be overlap in the roles that one person plays. So player number one is the grantor, sometimes called a settlor or a donor. That's the person who has property. So let's say I'll be the donor in this scenario, and the property that I have is this pen. So the second player in a trust scenario is the trustee. The trustee is the person or entity, it could be a bank or a trust company, who watches over the property, who owns legal title to the property, and who uses the property for the benefit of the third person in this scenario, who's the beneficiary. So a good example of how this works is I'm the donor, I have this pen, I want to give this pen to Jackie. I say, Jackie, hold on to this pen for me, and if my sister wants to use this pen, give it to her so that she can use it. And then when she's not using it, Jackie's going to take care of the pen, make sure it stays full of ink, make sure nobody steals it. It's a stupid example, but it just goes to show that a trust is a relationship. It's not dependent on there being millions of dollars. It doesn't even have to be in a bank. Now, usually trusts that most people talk about are trusts that have significant assets in them, because it really doesn't make sense to go through all of this effort if you're not talking about some level of wealth being within the trust. And so often trusts are, the assets are held at a bank or a financial institution, an investment company, because one of the trustee's responsibilities is to ensure that the property not only stays protected, but also receives some reasonable return. So you don't want it to just sit there, you want it to grow so that as the beneficiary uses the trust, it replenishes itself. So this is the three-part trust that gets set up. Now, a special needs trust is special because it gives the trustee a great amount of discretion as to whether or not to make distributions for the beneficiary. And this discretion is what prevents the assets of the special needs trust from being countable assets for purposes of means-tested benefits. An example is, let's say that the beneficiary needs $300 for housing. The trustee can say, no, that sounds like a bad thing, but it's actually a good thing. Because the trustee can refuse the beneficiary that $300 for housing, that means that when the state looks at that $300 or the assets of the trust, they think, well, okay, these funds aren't really available for this beneficiary's housing, therefore we can provide funds for this beneficiary for their housing. So it's this discretion that the trustee has not to make payments for the beneficiary that is the key to why a special needs trust works. Now, The trustee, of course, is there for one purpose, and that purpose is to actually provide for the beneficiary. And so typically what most special needs trusts will do is they will list a variety of things that they would like the trustee to consider making distributions for those purposes. It is my hope, but for which I impose no legal obligation, that the trustee will use the funds of this trust to make my child's life as pleasant as possible, to provide for travel, to provide for entertainment, to provide for transportation, to provide for technology, education, what have you. But again, because none of these things are mandated, even if they were to fall within the scope of what a means-tested benefit provider was looking at, they would say, well, but these aren't guaranteed. The beneficiary can't demand these funds for these purposes, therefore they're not going to be countable assets. So here's some of the great things about a third-party special needs trust as compared to a first-party special needs trust. And again, the difference between a third-party special needs trust and a first-party special needs trust is that a first-party special needs trust, the beneficiary can contribute assets. A third-party special needs trust, the beneficiary cannot contribute assets. And so again, it's a third-party special needs trust that we would typically recommend setting up on the front end if you have a child or other loved one with special needs. So the benefits of a third-party special needs trust. Number one, obviously, the assets, if properly drafted, and as long as the trustee isn't making wrongful distributions for wrong purposes, aren't going to be considered countable assets for purposes of means-tested benefits. That's the big one. Number two, you can choose who's going to be in charge. You get to choose who the trustee is. You can choose who the backup trustee is. You can choose who 10 backup trustees are. If you're concerned that, 4, 5, and 6 aren't going to serve, you get to pick number 7. You can go as far with that as you want. Most people choose usually just 1 or 2 or 3, but again, especially if you're dealing with a much younger person, you can get as detailed as you want with it. You can provide for different avenues for trustee succession. You can say, when I pass away, I want my oldest daughter to serve, and if she can't serve, she can pick somebody to serve. And if she can't pick somebody, or doesn't pick somebody, then I want my oldest son to serve. And if my oldest son can't serve, then he can, you can get as detailed with it as you want. The second big advantage to a third-party special needs trust, there's no contribution or total asset caps. That's also true with a first-party special needs trust. It's not true with, for example, an ABLE account. An ABLE account, once that ABLE account reaches $100,000, that will disqualify a person from receiving certain Social Security benefits. Like discussed previously, an ABLE account, there's a $15,000 annual contribution limit. That's not the case with a third-party special needs trust. You can have $1 billion in a third-party special needs trust, and the government's not going to look at that any differently than it would if the trust had $1,000 in it. Another great advantage of a third-party special needs trust is that it can accept any type of property. So we talked before about the family trust, the family camp rather. So real estate can go into a special needs trust, which can be a huge benefit if maybe this is your only child and you want to keep this property in the family. That's a great way to do it. You can still ensure that they get to use the property, but because it's not legally in their name, it's not going to be subject to their creditors, including the creditors after they die, which is MaineCare estate recovery. So that again is the huge one. You can say, after my child Nancy with special needs passes away, I want the remaining assets to go to Nancy's spouse. If Nancy's not married, I want it to go to her kids. If she doesn't have kids, I want it to go to my other children. If my other children aren't alive, I want it to go to all my grandchildren. You can get as detailed with it as you want. Another great thing about a third-party special needs trust, it can be set up for anybody. There's no age limit. There's no disability definition that you have to meet. That being said, would you want to go through the trouble of setting up a special needs trust for somebody who didn't have a disability? Maybe not, although there might be some advantages to it. These types of trusts, I suppose, are useful for other purposes. For example, maybe a child with substance abuse problems or other certain financial problems. There's some creditor protection here that's not available in a typical trust, although There are other ways of dealing with those particular situations, so it probably wouldn't be the best vehicle, but it could still work. So those are really the big ones. So third-party special needs trust, it is the way to go. Now, there are two approaches that estate planners tend to take with third-party special needs trusts. Some will actually set up a third-party special needs trust in your will, or if you have a revocable trust as a will substitute, they'll put it in your rev trust. So basically, the special needs trust doesn't exist until you pass away, at which point it gets created. The alternative is to actually create the special needs trust now while you're alive, and have it actually be a living, breathing entity while you are alive. And for that to happen, all you really need to do is set it up that way and stick $1 in it, and that's sufficient. The benefit of setting up a standalone special needs trust while you're alive, there are several benefits. Number one, and this is a big one, this allows you to tell your friends and relatives who may be considering including your loved one with special needs in their own estate planning. It gives them an easy way to do so, where they don't have to create their own trust. All they have to do is make reference to this existing trust. So that's really easy. You might say to your parents, for example, if your parents are still alive, hey, listen, I know that you are providing for me, or that you might provide for me, and a typical estate plan usually says something like to my issue per stirpes, which means to my kids, but if my kids aren't alive, then to my grandkids. So if your parents have a plan like that and you predecease your child with special needs, your child with special needs stands to inherit under your parents' will. So if you're comfortable talking with your parents or with your brothers or sisters, maybe who don't have children of their own, who may be providing for nieces and nephews, it provides a really easy way for them to make provision. You basically say, hey, I don't expect that you'd leave anything to my child, but if it's at all a possibility, even if it's a contingent possibility, even if 10 people have to die for this to happen, if you could include this one sentence in your will that basically says, if any assets are to go to child, they will instead go to, and then you list the name of the trust, it just makes it very easy for them. Another advantage to having a standalone special needs trust, as opposed to having one that kind of springs into existence under your will when you pass away, is that it allows you to name that special needs trust as a designated beneficiary of accounts. So if you are interested, for example, in probate avoidance, this allows those assets to bypass the probate process and go directly from whatever, whether it's an investment account or retirement account, to the special needs trust. Another advantage to this, and this probably goes a little bit beyond the scope of our topic today, is that under the new Secure Act, which is the new law that went into effect in January that deals with retirement benefits, they're no longer stretch IRAs for most people. So for the typical person who receives retirement benefits from somebody who's passed away, not including a spouse, for the typical non-spouse person, they're going to have to take out and withdraw those benefits over the course of 10 years. So that's a lot of income tax hit. If properly set up, a special needs trust can accept retirement benefits in such a way that the withdrawals the required minimum distributions can actually be made based on the beneficiary's life expectancy, which can result in a lot of tax deferral. So that's something to look into as well. And again, that's only possible if you have a standalone special needs trust that exists. Now, there is a little bit of ambiguity under the law right now because this is all very new law. There's not much guidance out there on what constitutes disabled for the purpose of the Secure Act. Although if you are considered disabled, or a person's considered disabled for purposes of Social Security, they're almost certainly going to qualify for purposes of the Secure Act. So moving on. One other thing that I think, I couldn't say enough great things about third-party special needs trust, but I do want to talk about the use of an Achieving a Better Life Experience account in conjunction with a third-party special needs trust. So an Achieving Better Life Experience account, again, it's just a bank account. It's a bank account that's actually owned by the beneficiary, by the child with special needs. So there are some great pluses to this. Number one is that it gives that person some independence. They have their own bank account. They get to decide what to do with the money. Another benefit is that it grows tax-free. in the account. The dollars that get put into it have already been taxed, but then they don't get taxed upon withdrawal. So that's a great thing. Another benefit is that contributions can be made by any person. So a parent can make a contribution, the beneficiary can make contributions. Maybe your aunt or uncle who wants to make a Christmas gift or birthday gift to the child, they can use the Achieving Better Life Experience account to make a gift, as long as aggregate contributions from any source don't exceed $15,000 in a given year. That number eventually will go up to 16,000 with the cost of inflation, but it's, you know, it doesn't rise a lot. It doesn't go up $1,000 every year. It's $1,000 every few years. So this is great, right? So again, not something to rely on, as we discussed before. The limitations, the annual contribution limits in the ABLE account don't make it a great vehicle for relying solely on it for estate planning. But in conjunction with a third-party special needs trust, it can be really great for your child. And in addition, it gives them a way to kind of sock away little bits of money that they may get on a regular basis to also better preserve their own special needs. Oh, I wasn't thinking, and I went out and I bought a scratch ticket and I won $5,000. Well, ABLE account's a great way to handle that. So again, so the remaining money though on the ABLE account does go towards repaying MaineCare. So again, if you have your choice as to what to do with funds, you wouldn't think, oh, well, let's start off and put, 15 grand into an ABLE account and then we'll deal with it, setting up a third-party special needs trust in a couple of years. No, set up the third-party special needs trust now. If you want to make a gift to your child, the best way to do it is to make a gift to the third-party special needs trust. In addition, the third-party special needs trust can actually make distributions to the ABLE account. So if oh, I really want my child to have some access to that money, put it in the third-party special needs trust, and then on an as-needed basis, the special needs trust can distribute it to the ABLE account. And that's a good thing, not just for the independence of the beneficiary, but also because the funds of an ABLE account can be used for more purposes than a third-party special needs trust can, things like housing and food. Whereas those distributions from a third-party special needs trust might end up making the assets considered countable. So you need to be careful there. Once they're in the ABLE account, then the beneficiary can use them for proper purposes under the terms of the ABLE account. So moving on to our third and final part here. Hopefully you're sick of the sound of my voice.
Before you move on, can I just, I got a question, but I just want to make one clarifying point as well. They have increased your ability to save in an ABLE account to $400,000 now total. So it's been increased from $100,000 to $400,000. There's still a yearly limit of $15,000 a year, but your total can be $400,000.
For purposes of receiving SSI? Because there's
for ABLE accounts.
Yeah, so ABLE accounts actually have asset limits. So the $100,000 limit was for whether or not you could receive SSI over $100,000. It will affect your receipt of SSI benefits. The actual cap on the total ABLE account varies from state to state. So in some states, it's as low as $260,000, $270,000, and in some states, I think it can actually be over $400,000. So but maybe we're talking about different things.
I'm talking about the total limit, so not the SSI. So I was talking about the total limit. It was based on a webinar I attended. I actually had another question from one of our participants, and she was wondering if there's a specific ABLE account program in the U.S. that you would recommend. Kathy's asking this question because you can there's no entity right now in the state of Maine that allows you to open an ABLE account in our state. Bangor Savings Bank is taking that on, but it won't be ready for a year or so. So you can set up an ABLE account virtually in other states. And so that's why Kathy is looking for your recommendation on maybe any other specific programs throughout the state.
Yeah, so I don't have, thank you. That's, by the way, you're completely right. Going to another state's not an issue. Most states will accept out-of-state participants while we're waiting for Maine to come up with its own program, which it has the legislature has authorized it. They just haven't finalized the rulemaking on it. So in terms of whether there's a specific state I would recommend, I don't think that there is. Each state differs a little bit, and it's really going to depend on your own specific needs. So each state has different asset limits. Each state has different requirements about what it requires in terms of documentation in order to set up the account. Some states may have more onerous requirements than others. In addition, they have different investment strategies. So some of it may, Jackie talked before about risk tolerance, and your own risk tolerance may factor into which state's program is the most appropriate. So, I mean, I think that there are a few different things that you need to look at, but I wouldn't worry about proximity. I wouldn't think, oh, I'd, rather look at a state that's closer to Maine. I don't think that should be much of a factor, but otherwise it's almost like saying, is there an investment person that you would recommend? Well, okay, obviously Jackie, but other than that, it's not a one size fits all question, and it's not a one size fits all answer. But I agree that it is important to actually give thought as to which state you choose.
Thank you. I've got a question. Jenny says, does a tax return have to be filed on a third-party trust and or able accounts?
Yeah, a tax return would need to be filed if there was income over, on a third-party special needs trust, if there was income over $100 in a year. So if you set up a third-party special needs trust during your life and you're thinking, well, I want it to be there, ready to receive funding when I die, which is what most people do, then you're not going to be filing tax returns all those years while you're alive. Well, nothing happens. It's only once the trust is actually funded that it will have a requirement to file a tax return. For an ABLE account, the funds are growing tax-free, so there shouldn't be any issue there. But I think, any tax question, you're better served checking with your own CPA or tax advisor.
How do you hold a beneficiary accountable? Is there any way within the language, like if a beneficiary is making decisions on behalf of an individual with a disability that doesn't meet their need, or isn't what the language of the trust is meant for? Is there an accountability?
So,
is there a way to hold them accountable?
You're kind of breaking up there. I'm sorry. Could you repeat that?
Yeah, sorry, my internet's not great. Is there a way to hold a beneficiary accountable on a special needs trust?
Okay, yeah.
So not the. Go ahead.
Yeah. So that's a great question. So typically on a special needs trust, the trustee doesn't really make distributions to the beneficiary, or if they do, they're extremely limited, like in the nature of an allowance. Usually benefits are paid directly to providers for whatever service or good is being provided. That's the safest way to ensure that the right use is being made, because otherwise, yes, you're correct, it does require some level almost of oversight, and that's a lot more than most trustees want to take on. They don't want to be making mistakes. They don't want to jeopardize the person's receipt of benefits. In some cases, they may reimburse a beneficiary back for things that they've paid out of pocket. But again, even there, you have to be extremely careful, because even if it's a proper purpose, if that beneficiary is socking away money and you don't know about it, and all of a sudden the next month their assets are too high, you can't just take the money back. So really in most cases, I would say you don't make distributions from a third-party special needs trust or first-party special needs trust directly to the beneficiary. I think that if you do want to provide them with spending money, the best way to do that would actually be to make a distribution to the ABLE account and then let them make the withdrawals from there. And I think if there are concerns about a beneficiary using funds from the ABLE account for wrongful purposes that are going to disqualify that account from being considered a non-countable asset, then you need to really reconsider whether it's an appropriate thing to be funding. They work great for a lot of people, but they don't work for everybody.
Great. And the last question I have is costs in setting up these accounts.
Yeah. So So, in terms of the cost of setting up an ABLE account, I don't think that there's really a whole lot of cost, although there may be a fee involved. Again, it's really going to depend, excuse me, talking for half hour straight. It's going to depend on the particular financial institution. In terms of a special needs trust, that is going to require working with an attorney. Most attorneys charge in an hourly basis. Usually a special needs trust, you're not talking about reinventing the wheel each time. So usually it's just a question of tailoring it to fit your specific needs, what you want to happen to the money afterwards, that sort of thing. I will point out that not planning tends to be much more expensive. I know that a lot of people think, oh gosh, attorneys are really expensive. Well, that's true. Attorneys charge more per hour than a lot of other professions, but if you're talking about planning on the front end and spending maybe 3 or 4 hours with an attorney to get a plan in place versus what happens if you don't put a plan in place, the difference is astronomical. I have a situation where I've been working with some clients for about 2 years. They had the mom passed away a couple years ago. She had done her estate planning somewhere else, not with me. Whoever did her estate planning, they weren't versed in special needs trust planning, and she had a child who had very serious alcohol problem, which resulted in very bad cognitive issues, and he is disabled at this point. And he inherited a quarter of this estate, and I have been working with his siblings, who fortunately are all on board and are willing to be patient, and also who have the resources to be patient in waiting for their own inheritances. We have spent hours and hours and hours and hours trying to unscramble the egg, basically, so that this man doesn't lose his benefits on an ongoing basis, and so that some portion of the property that he has inherited is being preserved for him on an ongoing basis. Now, the best we can do after the fact is a first party special needs trust, which means when he passes away, that money is going towards paying back the state. No way around that. So right off the bat, there's potentially, I won't say how much, but potentially a lot of money that could have gone towards his own kids. He has children. They're not going to get most of that, if any of it. Not to mention that we have spent far more than 3 or 4 hours trying to do this. We've had to have court involvement. And again, none of this would have even been possible, but for the fact that his siblings, one, all cared about him enough to say, like, yeah, we'll wait for our own inheritances to try to sort this out. And number 2, they were in a financial position where they could wait. For a lot of people, they're not willing to wait because they can't wait. They have their own issues. So it's sort of a long way of saying, in terms of cost, I don't want to get too specific because every client's different. Some people have a lot more questions than others. Typically, I would say, maybe 4 hours, 5 hours. But I would also point out that your level of preparedness coming into a discussion with an attorney is going to make a big difference about what the ultimate cost is going to be. And actually, I think that's probably a good place to turn it over to Jackie to talk about that.
Yeah, so I can talk a little bit about my experience, if that's okay. So I didn't have anything set up for myself as far as any of these legal documents and estate planning. And I set up a special needs trust, another trust for my other kids, the power of attorney, medical directives, will. I probably spent about $1,300. And that was with lots of questions in the meantime. And then, but I think it's well worth the money. I mean, it gives such a peace of mind, and we need to have it done. It's really important. So I don't find that it was too expensive, especially if you weigh the cost of not doing it. And I'm just sharing my personal experience, as a mom and getting that stuff set up.
Jackie, could you maybe talk a little bit about the work that you might do with a client prior to getting an attorney involved and how that might save some cost on the ultimate legal fees?
Yeah, so the process that I was talking about when I was talking about our 5-step process, we'll walk through a lot of questions. And we'll talk about needs and how much you think you might want to leave for a child if that's what you're working towards as a goal. We'll set up your accounts like your retirement accounts and the other types of savings accounts to gauge what you might have. So basically, we organize the finances. And then as you're doing that, you're going to have an idea on what you have, where it is, and how you want it left to your heirs. So that's really a good start. And then also with life insurances. I mean, if you go through the process and you organize all your thoughts on that, then when you meet with Tudor, you're going to know what you want, and you're going to be able to tell her what you're thinking about, as opposed to fielding questions like, should I leave this life insurance to this person, or 50% of this to that person? I mean, obviously she's there for questions, because I didn't have my thoughts wrapped around it, and she helped me through all of that. But I know that if you do some pre-work on this, it will help a lot. And also making changes afterwards, like I did. I set it up one way and then decided, oh, wait a minute, I want to do something a little different, you know. So that would cost money. So the more work you do, the better off you are when you go to see your lawyer. It's easier to get it done. Less cost,
Yeah.
it's more cost effective. And I can help organize that and help get the thinking going and point out things that we need to think about and pull it all together.
Yeah, I've heard the analogy used where, you know, when it comes to assisting somebody and planning for somebody with special needs, it's almost like this football analogy where you have a quarterback and then you have all these other members of the team and everybody's working towards the same goal. But usually there's one person who's kind of bringing in and, telling, okay, this is the play we're going to run. And I can't believe I'm using a sports analogy. I'm not a sports person, but maybe some of you are. But, somebody in a position like Jacki is in, a financial advisor with some understanding of these basic concepts and who understands your personal situation and has the time to talk to you about your goals and your concerns and your needs, she can really help streamline the process. I mean, I am more than happy to talk about all of those things with my clients, but the way things are structured, I mean, I'll just be perfectly honest with you. I mean, attorneys bill by the hour. So if you can work out a lot of those questions with someone like Jacki on the front end, then when she says, okay, I'm ready to like call in special teams here or linebacker or whatever I am, then because things are already kind of organized going into it, it makes things quicker on my end. I can say, okay, I might have 5 questions for you instead of 15. And so that really, that limits the amount of time and therefore it limits the cost. So it's,
right.
I think it makes a lot of sense to proceed in that type of fashion.
Yeah, quite often financial advisors, attorneys, CPAs, tax advisors work together as a team. And that really helps in all kinds of ways. And we don't charge by the hour.
Yeah, exactly. So I think I've said pretty much about everything that I wanted to say. Again, just to kind of summarize, for anybody dealing with special needs trust planning, work with somebody. Eventually, you're going to want to bring in an attorney. I would not use any off the internet trust that you find. It's not safe. It might work or it might not, but you get what you pay for. I've definitely seen, I wouldn't say actually I've seen any off the internet special needs trust, but I've seen off the internet wills go horribly wrong. They cover the things that you think of. They don't cover the things you don't think of. They don't know the questions to ask. So I would work with an attorney. I'm not the only person in town. If for whatever reason I'm not the right fit, find somebody who is. This isn't the type of thing you want to risk. Just hoping to try to figure it out. And then once you have a special needs trust, ensure that your will or revocable trust actually funnels your assets into it after you or your spouse, if you have a spousal planning in there, passes away. Third step would be talk with your other family members or any friends who you might have special concern for your child. Talk to them about making sure that their own planning is also going to funnel anything into this trust if if it results in if it turns out that that person, your child, is going to be inheriting from them. And then lastly, check your beneficiary designations. This is something people forget to do a lot. Like I mentioned before, people, oh, well, I'd leave everything to my children, so it's fine. It's my grandchild that has an issue. Well, not if you check the little box that says per stirpes. That means that if your child predeceases you, then everything's going to go to your grandchild. Or not everything, but a portion is going to go to your grandchild. So you need to make sure that your beneficiary designations are set up correctly. I strongly advise actually having the attorney who works with you on the special needs trust actually review your beneficiary designations and just look them over. Usually they're pretty simple forms. It doesn't take long for them to do that. In some cases, they need to be drafted. Specifically, it's more than just writing in a name. You may actually need to write in some additional language, and that's, again, something that you would want to have an attorney do, especially if you're dealing with retirement benefits. There are all kinds of little loopholes. Things have to be done correctly if you want to try to get that stretch payout. And if you do it wrong, you could end up with a 5-year withdrawal period. So you want to make sure, if possible, you're getting stretch. Second, you'd be getting a 10-year period, and last resort, you'd be getting that 5-year payout. So, so that is, I think that is my piece. Jackie, do you have anything else that you want to add?
No, I do want to mention that we're talking about estate planning for special needs families that have children with special needs, but really everybody needs it because it's important. If something happens to us, we want to be able to have some control of our assets, or know that whoever is controlling them is doing doing what we want with them. And it's time consuming when things go to probate court, and it costs a lot of money. So when I talk to my clients, I talk about estate planning and how important it is, and to get things, that's part of setting yourself up properly.
Yeah, no, absolutely. Yeah. And I think, there are different scenarios that to me are like red flags of like, oh, you have to engage in some planning here. And one, of course, we've talked about today is when you have a loved one with special needs. Another one is if your assets are over the estate tax thresholds. Right now, the federal estate tax threshold is very high. Most of us, it's not a problem. Here in Maine, we have state estate tax. If you are a Maine resident and you're even combined with a spouse, if your assets are over 5.8 million, you could be you could end up with some state estate tax repercussions. So it's something you would want to plan for on the front end. And that includes not just what's in your estate. It could include life insurance. It could include all kinds of things that you might not think about as being, probate assets. So that's another consideration. Another consideration that I think, talk to an estate planner is if you have a blended family. If your children are not the same as your spouse's children, or if one of you doesn't have children and one of you does, you may have a desire to provide for your spouse, but to ensure that if your spouse outlives you, that your assets that you earned during your life are going to go to your own kids, or that part of them are going to go to your own kids. So that's something you really need to work out on the front end. And included in that is, and this is something not everybody knows, but a spouse in the state of Maine, and I think in every other state in this country, is entitled to a share of a decedent's estate. So you can't simply say, well, my spouse and I have an understanding, and I'm going to leave everything to my kids, and he's going to leave everything to his, and we're fine with that. You might have an understanding, but if something happens to your spouse and all of a sudden they have creditor issues and you die, those creditors can force your spouse to take a share of your estate. It's going to come out of what your kids should be inheriting. So that's something you need to plan for. And then lastly, I think, the other kind of big thing that I always, I think, talk to somebody is if you have a child with or a loved one with any other issue, not special needs, but whether it's a gambling problem, creditor problems, substance abuse, anything like that, you're going to want to be careful of how you plan. And some people say, well, I'm just not going to leave anything to them. And while that certainly avoids some problems, it creates others, and it can create problems for the kids that you do leave everything to. It can create fighting, and there are better approaches if you still want to provide for somebody, but you're concerned that providing for them might cause issues. So I think that's it. There was one other one, it popped in my head, but then it popped right out. If I think of it, I'll chime in, but.
Sounds
You
good.
know what it is? If you have property in multiple states, real estate in multiple states, particularly if you own real estate somewhere like Florida that has a really onerous and expensive probate process, you're going to want to engage in some planning so that you can avoid probate in the state of Florida. Probate in Maine is not a big deal as long as you don't have, major privacy concerns or anything like that. Going through probate here is, who cares? It's fine. But if you own a Florida condo, you do not want to deal with that process. Estate attorneys down there can charge based on a percentage of the size of your estate, which can end up costing you an arm and a leg. So don't do it.
Thank you so much. That was a wealth of information. We do have a question. While we get an answer, I'm going to launch our poll so that individuals can start taking the poll. If you could just take a few minutes to answer those questions, that would be great. We have a question about an individual who had a special needs trust written by an attorney who retired. Will a new lawyer rewrite it?
I'm sorry, I heard a special needs trust written by a retired attorney?
Retired lawyer, yeah. Now, the lawyer's not retired, and will a new lawyer rewrite it?
I'm sorry, I still couldn't hear the last sentence
I
that you
can't
said.
hear it,
Will a new lawyer rewrite it?
Do they need to rewrite it?
That was just, the language is just will a new lawyer rewrite. So if it needs to be rewritten, something to it.
Oh, it needs to be rewritten. Yeah. Yeah. So, so typically a special needs trust that gets set up as a standalone trust during life is irrevocable. So it doesn't really get rewritten so much as a new one gets written and takes its place. If there's already property in the special needs trust, which in most cases there is not, then you would really need to deal with modifying the trust, which would require court involvement. But if you haven't actually put anything into the special needs trust, really the easiest thing to do is just to start fresh with a new one, because you have to create a new trust anyways. And the old trust just sits out there and does nothing and has nothing in it. It has no effect. So it doesn't matter. You don't need to close it or tear up the document or anything. Typically, I mean, there's been a lot of change in how special needs trusts are drafted over the past 5-6 years. So if it is an older trust, it may be that it was drafted in kind of the old school way of thinking, which was that the trustee was prohibited from making distributions for certain purposes, specifically anything that would affect the receipt of means tested benefits. And actually the more modern way of drafting special needs trusts now is just giving trustees complete and total discretion and actually allowing them to make distributions that would affect the receipt of means tested benefits if in the trustee's discretion that's actually in the beneficiary's best interest. Because in some cases it may be, what's the expression, throwing out the bathwater, throwing out the baby to save the bathwater or whatever. You don't want a limitation preventing a greater good. So I would just, even if you have an old special needs trust and you're like, oh, well, I'd like to change the remainder beneficiary, there are most likely going to be a few other tweaks that will get made just to kind of modernize it if it's been a while since it was set up. Hopefully, again, I'm sorry, I was having a lot of trouble understanding the question. Hopefully I answered it. If not, let me know.
No, you did. I'm not video sharing. My internet connection was pretty unstable. That's what I get for trying to get into the office. I don't see any other questions right now. We've got some comments saying thank you for this well-delivered information, very easy to understand and follow on with. And thank you so much. This has been extremely helpful. So I'm going to keep the poll up. If individuals can continue to finish filling that out, that would be great. We'll hang on for a few more minutes while we wait for those of you to finish the poll. And if you have any other questions, please feel free to add them to the chat box. I want to again thank Jacki and Tudor for their time today and volunteering to be here with us and provide us with much more of an education. Financial planning can be so overwhelming as it is, and then adding a child with a disability on top of it just adds to the stress. And so providing some clarity around that was extremely helpful, and it was giving us a foundation to build off of. So again, thank you so much for your time today. We greatly appreciate it.
Thank you for having us.
Thank you.
I'm just
I
going to give it a
appreciate your-
few more minutes.
I'd like to encourage any of the listeners to reach out if they have any questions or thoughts, and or they just want to talk a little sounding board on their own situations. You can get my number through Carrie, and feel free to reach out.
I will post Jackie's information in the chat box so it goes to the bottom. It's at the top right now, but we'll repost that right now so that you can see that. And you're getting a lot of thank yous. Good information. Thank you so much. So, if you fill out the poll and you don't have any other questions, this would effectively end the webinar at this stage of the game. I'm just going to give it a few more moments with the poll. We've got 83% who have participated. Tudor, do you want to provide your information?
Oh yeah, so I'm with the law firm of Jensen Baird Gardner and Henry. We're located at 10 Free Street in Portland. My phone number is 775-7271. You can also reach me by email, which is usually the best way to reach me if that works for you. It's T as in Tudor Goldsmith, GOLDSMITH, at J as in Joy, B as in Boy, G as in Garden, H as in Henry.com.
And I put that in the chat box as well.
Oh, thank you. Perfect.
Yeah. And that's, I don't see any other questions at this point in time. So with that, I thank you guys for being present with us today. Like I said earlier when we started this, we have recorded this webinar. We will get it up on our Facebook page as well as YouTube. I do apologize for my internet connectivity issues. It'll also be on Facebook Live within a few moments after we stop the webinar. So you will have availability to review the information in case you want to go back and take some more in-depth notes if you feel like you've missed something. And then if you don't have Tudor or Jackie's email, forget to take it down, you can always contact us at Maine Parent Federation and we'll provide you with the referral as well. So I see that everybody has taken our poll, so we will, at this point, end the webinar. Thank you again, ladies, and I hope everybody enjoys the wonderful weather and welcome summer this weekend. So have a great day. Thank you so much.
Thank you.